The Honorable, the Supreme Court.
Good afternoon. Thank you all. Appreciate it. Go ahead, call the case if you will.
Good afternoon, Your Honors. The matter before the court this morning is the case entitled Garrett Hirchak versus Tyler Hirchak, Thomas Hirchak III, and Hirchak Brothers LLC, case number 24 AP 067. Representing the appellant, Garrett Hirchak, Manufacturing Solutions Incorporated, and Sunrise Development LLC, is Christopher Roy. Seated at counsel table with Attorney Roy is Monica Allard. Representing the appellees and cross-appellants, Hirchak Brothers LLC, Thomas Hirchak, Tyler Hirchak, and Hirchak Group LLC, is Kevin Henry. Seated at counsel table with Attorney Henry is Angelina de Beaupois.
Okay,
Sorry.
thank you very much. And good afternoon, counsel. We'll hear from the appellant. First, please, for the record, identify yourself and your client.
Thank you, Your Honor. May it please the court, my name is Chris Roy, and I represent the appellants in this matter, Garrett Hirchak, Manufacturing Solutions, Inc., and Sunrise Development, LLC. The three appeals before the court today relate to the unfortunate dysfunction and demise of a once hopeful business relationship between three brothers after they acquired their father's auction business in 2019. By way of this appeal, one of those brothers, Garrett Hirchak, and two of his businesses are simply seeking to be made whole. That is, they're seeking to recover funds that were advanced for the benefit of the LLCs and seeking payment for services that were provided indisputably for the benefit of the businesses. One of the issues that's been briefed and in some respects is not terribly important is the question of the trial court's authority to determine proper terms for a buyout. There are two avenues for that. If there's wrongful conduct by an owner, section 4081.5 of Title 11 allows for dissociation. On the other hand, if a minority owner is being frozen out through oppressive conduct under section 4101A5 and B, a buyout can also be ordered by this court.
Mr. Roy, that was assumed that there was no agreement between the parties on dissolving or buying out, that there's no buyout provisions in when they started this entity together.
There is a provision for voluntary buyout, but not one that provides under a judicial dissolution or buyout. So the parties agreed that the best path forward was to submit the dispute to the court, which they did. I would note, simply for the record, that my client is not appealing the determinations regarding his alleged breaches of fiduciary duty below. It's not because he agrees with those findings. He understands that those are factual determinations. He does want to emphasize, however, that notwithstanding the findings that were made with respect to his conduct, it is also important to remember that the other two brothers did engage in oppressive conduct as well. Namely, they unilaterally decided to stop paying his miscompensation. They unilaterally stopped paying his business invoices. And ultimately, they unilaterally decided to terminate his employment, even though that was one of the central terms of the original arrangement.
But weren't some of these things discussed at a meeting that was called for that he did not attend?
There was a meeting in the summer of 2022 where Garrett was asking for advanced thought and planning to go into a meeting, as opposed to the three owners just going in and shooting from the hip to come up with things. And that, frankly, was the fundamental sort of disharmony between the brothers. Garrett Hirchak, who had more of a business background, very much focused on planning and data and having things thought out in advance. The other two brothers were more, would make decisions more intuitively and wanted to just get together and make decisions. And that sort of disconnect, frankly, from the very beginning, I think led to what was eventually the ultimate dysfunction and demise of the three brothers being able to work together. Now, before any of that occurred, however, Garrett Hirchak advanced $300,000 that allowed Hirchak Group LLC to acquire the real estate on which the auto auction business in Williston took place.
What were the terms of that advancement?
The terms of that advancement were $300,000 was required by the bank in order to finance the purchase, and Garrett provided the $300,000. And therefore, by statute, under 11 VSA Section 4060, that was deemed a loan that is entitled to be reimbursed. The trial court had cited to one secondary source about family businesses creating a presumption of gift. But first of all, there's no Vermont authority in favor of that. In fact, no case decisions were cited by the trial court. But it also had to do with sort of small tasks. You know, if you own a family grocery store and you go in on the weekend and you sweep the floor, are you entitled to be, billed for your time doing that? It wasn't $300,000 advances that importantly created immediately $300,000 of equity in the sole asset of the LLC. So it was truly a transfer of $300,000 of value from Garrett personally to the LLC.
Mr. Roy, you just cited that statutory provision, and doesn't that only apply if there is an agreement between the parties?
No, I think that the statutory language doesn't talk in terms of agreements between the parties. It talks about a duty to reimburse under certain circumstances. So Section 4060A speaks in terms of the LLC being obligated to reimburse a member for payments made in the ordinary and proper conduct of the activities of the limited liability company. And then subsection C says that the LLC shall reimburse a member for an advance to the company beyond the amount of contribution.
And
So-
it applies even if there is a breach of fiduciary duties?
Yes, and the reason for that is a couple here. First of all, there was not a separate count or claim for damages relating to breach of fiduciary duty. Section 4060 does not include any language that allows for that. In addition, no evidence was presented at trial that would allow the fact finder to somehow reduce or modify the amount that was loaned and whether or not it was to be paid back.
The court did use the breach of fiduciary duty, though, to find in part that there was oppression, right?
Well, yes, but again, with respect to the $300,000, it's important to point out that's at the very beginning. The three brothers are getting along great, and they've just bought the business from their father. There hasn't been any deterioration in the relationship. At that point, Garrett hasn't, started using MSI for the financial and HR service. None of that had occurred yet. So $300,000 was advanced in good faith, out of necessity.
Well, out of necessity, I thought the brothers had said, we're going to do this. And then Garrett said, no, you're not. I'm doing it.
After the fact, there is a suggestion that they were willing to contribute $100,000. There's a couple of responses to that. First of all, if they had, those $100,000 advances would be entitled to be treated like loans, just like Garrett's was. And secondarily, they weren't really offering to pay $100,000. What they were trying to do is take a claim that wasn't before the court, namely the Bridge Street property and payments underneath that, and take a alleged right to future payments and write them off in return for Garrett paying the same $300,000. The difficulty with that is there wasn't any effort to do a net present value of those future payments or anything, because that's not the way the other two brothers thought. And ultimately, the trial court did find that Garrett was under no obligation to reach some agreement that involved the father and the Bridge Street property, and that wasn't before the court at the time. So ultimately, if you strip away some of the distractions, the fact of the matter is $300,000 was advanced. It inured to the benefit of the LLC. It created equity that is in the LLC. And under the statute, it is obligated to be treated as an advance, as a loan, and that a loan that accrues interest.
How much interest? What rate?
The rate of interest, and this is, I just set this up this way, this would be a nice segue. The interest, there was no, as unfortunately, and I think this is one thing the three brothers can agree on, that there wasn't nearly as much documentation as anybody would have liked with respect to this, brotherly arrangement. And consistent with that, there was no discussion about interest rates.
So who should bear the loss of that, though? I mean, so everyone getting together, the three brothers are getting along, they decide to form these LLCs, and there's contributions and all the rest, and then don't do appropriate documentation, says that there's like three people who weren't necessarily related. So who was in the best position to avoid that by making sure the proper documentation was in place?
Well, this court has decided that if you have damages that are liquidated or reasonably ascertainable, that you're entitled to prejudgment interest. And absent a specific agreement that provides otherwise, the party is entitled to the legal rate, which is 12% per annum. And as a practical matter, that's a high interest rate. And I think it's a vestige of earlier times when it was easy for a town clerk to do 1% a month. Be that as it may, it also creates incentives, frankly, for parties to negotiate interest rates. That didn't happen here, and the law that this court has declared has made it very clear that absent an agreement as to the interest rate, the rate is the legal rate of 12% per annum. And this played out in the New England partnership case that involved two appeals to this court. In the first one, the trial judge, who was also the trial judge here, decided that notwithstanding the lack of an agreement as to an interest rate, she thought imposing the legal rate was unfair. And it was appealed to this court. This court reversed it and sent it back down for determination of interest. She then determined that 12% was too much and equitably came up with a 6% interest rate. And that was appealed to this court, and the court said, no, the legal rate is 12%. And that's what is played out here. And also, frankly, the trial court made no effort to distinguish this case from the circumstance in New England partnership. The last short piece I'd like to mention is there are also some advances and invoices during the April 2020 to September 2020 timeframe that the court invalidated and didn't allow for collection. And we think that was inappropriate as well. One thing to keep in mind, literally April 20 to September 20 was the most hectic, chaotic period of COVID. And during that period of time, they were trying to transfer a business at the same time the business was trying to figure out how it was going to survive. So it was a very hectic circumstance. The only point that I'd like to make in that regard is there's no dispute about the amount of the advances that were made. There's no dispute about the services that were provided. There's no dispute that the rates charged were the same rates that had been charged and approved by the court earlier. And therefore, my clients believe that they're entitled to those items during the April 2020 to September 2020. As a consequence, the appellants would ask this court to allow him to be reimbursed for the $300,000 loan for the down payment, to recover $45,000 in advances that were made to Hirchak Brothers during the summer of 2020, that MSI and Sunrise are entitled to recover on their invoices, and that this matter be remanded back to the trial court for the calculation of prejudgment interest on all amounts recoverable. Thank you, Your Honor.
Okay, thank you. We'll hear from the appellee. Please do the same if you would. Identify yourself and your client.
Thank you, Your Honor. My name is Kevin Henry, and I'm here representing Hirchak Brothers LLC, Hirchak Group LLC, Tyler Hirchak, and Thomas Hirchak.
Thank you.
Let me address what I think should be the easiest claim in this case, which is the claim of oppression by Garrett Hirchak. I think, we laid out the facts in our brief, and I'll just highlight. Garrett Hirchak spent what we would argue is the entirety of this partnership in breach of his fiduciary duties, trying to take advantage of his brother. In the period of 2020, the claim is that Toby and Tyler, Thomas Hirchak III goes by Toby, so we use first names at trial to avoid confusion. Toby and Tyler were trying to figure out what was going on with this business. Garrett Hirchak refused to turn over the books to allow them to figure out what was going on with the business from March until they had to sue him in September of 2020. Once he finally did turn over the books, they engaged in discussions with Garrett Hirchak, and they said, look, we're not going to continue to let you be employed paying yourself whatever it is you want. If you want to be an hourly employee, you can punch the clock, and we'll all punch the clock. He refused. Then in December of that year, he filed an action to dissolve the company. And all of the while, he's saying that Toby and Tyler refused to pay him. He's the one that had the check. He was in control of both sides of the relationship between Hirchak Brothers LLC and his company, MSI. So he was the one deciding which bills got paid. Toby and Tyler didn't even have the opportunity to do that. So the idea that he was somehow oppressed is, as the trial court found, easily dealt with. With respect to the $300,000, the question was asked, what were the terms? And it's an excellent question because there were no terms. This is a decision that Garrett Hirchak made, and we would argue he made it with the intention to gain leverage over his brothers, because that was, we spent a week in front of the trial court laying out all of this evidence. The trial court correctly found that Garrett Hirchak was in breach of his fiduciary duties from the beginning, including with respect to this advancement of the $300,000, where Toby and Tyler wanted to be on equal footing and were trying to find ways to do that. And Garrett Hirchak refused. He simply said, no, I'm paying the $300,000 and don't worry about it, essentially. And now, years later, he comes back and says, oh, that was a loan. And not only was it a loan, I'm entitled to interest. Well, there are a variety of problems with that argument, beginning with the fact that it was a breach of fiduciary duty. But you
So
start.
what's your theory on why he gave the $300,000? He gave it so that he could use it for leverage against his two brothers?
Yeah,
I'm missing the connection, and I apologize.
sure. So, well, you'd have to, going back, and our theory of the case is that Garrett Hirchak got into this relationship and knew from the outset that he was going to exert leverage over his brothers to take what he wanted. There's three aspects to this business: the auto auction business, the real estate and commercial. Garrett wanted the auto auction for himself. Ultimately, that's how it played out. He tried to extract that piece of the business for himself. And our theory of the case was that he probably went into this with the idea that he was going to do that at some point. So that's the theory on leverage. But beyond that, Section 460 has no application here. Section 460 is narrowly applies. First, it only applies to advances, contributions that are beyond what a member agrees to make. This is not even a contribution. And certainly it can't be said that it was beyond what he was willing to make if he made it. Separately, it only applies, and I think both of these are required, when the advance gives rise to an obligation of the company. And it can't be said that it gave rise to an obligation of the company here because there was no agreement with the company. There was no terms, there's no loan agreement, there's nothing. It's simply $300,000 hoisted on the company. Now, to be sure, it was a benefit to the company, but it's bad faith to make that down payment, intentionally leave out any terms so that you always have in your back pocket something you can go back to and say, oh, by the way, you owe me $300,000 with interest. So for that reason, this 460 has no application. And even if it did, somebody else asked whether that applies even if you're in breach of fiduciary duty. And I think that the trial court determine this? And the answer is no. You can't take advantage of one provision of the LLC Act when you're violating your basic obligations of fiduciary duties. So at the end of the day, the $300,000 is a purely equitable issue. And the court was more than justified in weighing the equities here, in determining that he doesn't get that $300,000 back. And
Can I ask you a question?
Certainly.
It's on a little bit of a different issue, but the prejudgment interest
Yeah.
on the invoices.
yeah,
Is there any equitable decision-making to be considered when making that decision?
yeah, and I'm glad you asked that, because that's what I was going to go to next. The answer in our view is yes, that the mandate for prejudgment interest applies to legal damage claims. It does not apply to equitable claims. We cited the cases in our brief that lay that out. And the award of those payments was not on a legal basis. It was on an equitable basis. And the reason for that is, my analogy would be, this is like the guy that comes to mow your lawn, even though you don't ask, and just keeps sending you a bill. The lawn gets mowed, but there's no contract. And that's what the court found here. There was no agreement. So all these MSI invoices were, again, foisted upon Hirchak Brothers LLC on terms that Garrett unilaterally decided. And so there was no contract, there was no agreement.
But they had paid a lot, well,
They paid a lot of them.
yeah.
In our view, more than they should have. But that being said, the court did order that some of these claims get paid on an equitable basis. And on those grounds, there is no entitlement to prejudgment interest. And so it is an equitable decision for the court to make. And then I do want to touch on our cross appeal, which is that the court ordered that Garrett Hirchak was entitled to his compensation for the year 2020. And we lay out in some detail in our brief the chronology of his breaches of fiduciary duty and the fact that for almost that entire year, he was working completely against the interests of the company. He was refusing to provide the books. He was refusing to meet with the brothers. He forced them to sue him to get the books turned back, all the while trying to exert leverage by proposing different buyouts, knowing that he had the information they needed to make that decision. So I think it's the reason the trial court was wrong there is that you can't, on the one hand, because I think the trial court did agree with this, he was complete breach of his fiduciary duties during that time. You can't be in breach of your fiduciary duties and be entitled to compensation for the very same period of time. So for those reasons, we think the trial court was simply wrong in awarding him that compensation. And with that said, we don't have any further points to make unless there's other questions.
All right, I think that's it. Thank you very much. Does the appellant have time?
Appellant has 1 minute and 53 seconds remaining.
Counsel?
Thank you, Your Honors. I would like to make two quick points, if I could. First of all, there's this discussion about legal versus equitable and prejudgment interest, which conjures up nightmares from law school about those distinctions. But unfortunately for appellees, that's not the test. The test is, are the damages liquidated or reasonably ascertainable? If they are, you have a right to interest. Then, if there are equitable claims that are not liquidated and not reasonably ascertainable, the trial court has discretion whether, as a matter of equity, to assess prejudgment interest. So if you look at the three cases cited by appellees, the McLaren case was restitution on unjust enrichment, a domestic situation where people were trying to untangle their finances. It wasn't a business situation. The Remis case, promissory estoppel, and then an interpleader case in the federal district court. Those are equitable claims that did not have liquidated, reasonably ascertainable damages. So the distinction isn't legal versus equitable. If it's liquidated or reasonably ascertainable, then you're entitled to interest. And at PRID case 150 through 161, we laid out with no dispute whatsoever each of the items and the date that they were incurred. With respect to whether or not the $300,000 was a loan or not, we will simply direct the court to the clear, plain, and unambiguous language of section 4060. They're trying to tie it into whether there was an agreement and whether it did other things or is pulled into other provisions in Title 11. Section C says a limited liability company shall reimburse a member for an advance to the company beyond the amount of contribution, which means it's not another capital contribution. It's something other than